Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here already, thank you for waiting patiently. While we wait, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with a vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on a bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us today for our online talk entitled Drafting and Proving Wills for Assets in Multiple Jurisdictions. My name is Joseph Khor. I'm an associate with Liew and Associates, and I'll be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Liew and Associates is a mid-sized law firm that was founded in 1985 by Dato' Ma Wing Kwai. Our able team today comprises 33 lawyers and a support team of 26. Dato' Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWK online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013. Some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for complimentary legal consultation. Details will be given at the end of this talk. Allow me to introduce my good friend and very able lawyer, Mr. Aaron Liew. Mr. Aaron Liew is an associate in our Corporate and Commercial Dispute Resolution and Individuals and Families Department. He is a Bachelor of Laws with honours from the University of Manchester, UK. He is called to the Bar of England and Wales in Middle Temple in November 2020. He was admitted as an advocate and solicitor of the Malaysian Bar in 2021 of the High Court of Malaya. He primarily deals with corporate and commercial matters, probate and administration of estates. He has vast experience in construction litigation, corporate and commercial litigation. Aaron, over to you.
Thank you. Thank you, Joseph, for the amazing introduction. I'm much obliged by your introduction, by the way. Good afternoon, everyone. So today's top point, what we will be doing is we'll be covering 4 different top points: an overview of estate planning, drafting wills for each or multiple jurisdiction, proving will in different jurisdiction, and also cross-border inheritance issues and solutions. The first part, overview of estate planning. So what is an estate? Basically, an estate is all the assets and liabilities where a deceased person had at the point of their death. That basically it means houses, apartments, bank accounts, cash, or any personal belongings which were pegged to their name at the moment when they passed away. There are two types of estate. The first one being testacy, where an individual who passed away with a valid will and where the will takes effect upon the death of the testator. The testator in this sense is someone who has already made a will during their lifetime. Intestacy, on the other hand, is someone who passed away without leaving behind a will. So what happens in the case of intestacy? All persons interested in the estate, who usually would be the beneficiaries, can make an application for grant of letters of administration upon the death of a person without a will. So grant of letters of administration would be a court document, a court order that allows an administrator to be appointed and to administer the estate affairs. So who are the beneficiaries? Section 6 of the Distribution Act sets out that the persons entitled to the estate and the manner of distribution, who includes the spouse of the deceased, children, parents, siblings, grandparents, and so on and so forth. So all these are mostly family members, next of kin, or even successors. So under Section 6 of the Distribution Act, this is like a very simplified table on the manner of distribution in the case of intestacy. So for example, let's say you only have a wife or a husband. When you pass away, your wife and or husband will be entitled to the entirety of your estate. Let's just say you have a house, you have a car and bank account, all of these will go to your significant other. If you have only children, let's say you have 2 kids, all of your assets will be distributed equally to these 2 children. If let's say you have a spouse and you have a children, your spouse will be entitled to 1/3 of your entirety of assets, and your children will be entitled to 2/3. So it's like, in the case of a house, your wife will get 1/3, your children will get 2/3 on the land title registration. So what actually is estate planning? Estate planning, it means like setting up a plan or devise a plan that would decide who will receive your assets and how your affairs will be managed when you passed away. So there are 2 ways to do it. The first one, and the more straightforward and simple and more common one, would be drafting a will. And the second will be a trust. Now, the second topic we'll be touching on would be on drafting wills for each or multiple jurisdictions. Before that, we would be going into the formalities of a will in Malaysia, where Section 3 of the Wills Act states that the maker of a will at that point of time must be of sound mind, which means that he understand what he is drafting, what he is preparing and executing. Section 4 would state that a testator would have to be 18 years old and above. And Section 5 would say that no will shall be valid unless in writing and executed in the manner prescribed, meaning that all will would have to be in written form, black and white, proper document. What should a will contain? Particulars of the testator, for example, your name, your IC, your address, and who would be your executors. Let's say you want to appoint your partner to be the executor, and what your intention, your wishes in the will. For example, let's say you wish to donate a certain money to, let's say, any trust fund or any charity, you can put that in as well. Beneficiaries, who would be your beneficiaries entitled to your estate, your assets and properties, and what's the date of the will, and your signature, alongside with the signature of 2 witnesses who would be witnessing you signing the will. So the appointment of executor, an executor is the person who has been appointed to administer the assets of your testator, of you who made the will. And he or she is responsible to carry out the wishes or requests of the testator. And this executor must be willing and capable, and he or she may be a beneficiary, be entitled to part or parcel of your estate. Or you can also have alternative executor in the event that the executor doesn't want to act or can't or unable to administer or carry out your wishes. So based on the Probate Administration Act, there must be a maximum of 4 executors at one point of time. So this can be seen in Section 4 of the Probate and Administration Act, and where it states that the representation cannot be granted to more than 4 persons at any point of time. And if there is a beneficiary who is an infant, or if a life interest arises under the will, Administration shall be granted to a trust corporation or no less than 2 individuals as executors. So let's just say if you have a child, a beneficiary who is a minor, who below 18 years old, so it will be necessary and under Section 4, Subsection 3 of the Probate Administration Act to appoint 2 co-executors to jointly administer the estates. The next topic would be what can be disposed of by a will. Section 3 of the Wills Act stipulates that property or interest in the property belonging to the testator or to be received by the testator. These may include personal or movable property, bank accounts, car, cash, in some cases, jewelry or personal belongings, etc. Real or immovable property, for example, like house, land, apartment, condominiums, shop lots, or sorts. Shareholding of a company, the shares of a company, let's say you have invested a certain amount of shares in a company, you're a shareholder of a company, all these shares can be included in the will. Partnership interest, which is something similar but in a partnership context, and interest given under the will of another individual. Let's just say that you are a beneficiary of someone else's estate, but the estate affairs haven't been attended to and some things remain under the estate name and pending to be distributed or administered. Your interest under that particular will can be included in your will as well. Now, the next topic is a lot of concerns would raise because nowadays a lot of people own foreign assets abroad, out of Malaysia. So what about foreign assets? So for properties out of Malaysia or abroad, for example, namely Singapore, Hong Kong, in the UK or in the US, all these assets can actually be included into the Malaysian will, as it can still be administered by and governed by a Malaysian law. Alternatively, you can draft a foreign will in the jurisdiction of the property and asset. For example, let's say you have a house or you have some bank accounts in the UK, you can draft up a will in UK, for example. In London, you own a house, then you draft up a will in London with a London local solicitors to set up your wishes on how your assets in UK to be distributed. So for this one, the separate law, or much so we would say it's a foreign law, foreign will be governed by a local law. There are two main distinct part of assets, one being the immovable assets and the other being movable assets. So for immovable assets, although you would have put it into your Malaysian law, it will still be subjected to the laws of the jurisdiction where the assets are located. So for example, you own a house in London, how the house can be distributed or passed to someone else will still have to be dealt with the English law, inheritance or things like that. Movable asset would be subject to the laws of jurisdiction where you are domiciled in. So let's say if you have a bank account in Singapore, you put it inside your Malaysian will, it can be dealt with and may subject to Malaysian law. So this is an example where Kelly owns a number of properties in Malaysia, an investment account and bank account in Singapore. Now she is considering to plan for her estate and thinking what's the best option to do. Kelly can include her properties in Malaysia and accounts in Singapore in her Malaysian will, which would encapsulate all the properties under her name in the will. Alternatively, she can draft up her will in Malaysia to set up her assets in Malaysia and a will in Singapore to set up her assets in Singapore. The next part would be the residuary clauses. What would it mean? Usually in will, we will suggest clients to include a residuary clauses in their will as a catch-all provision, which means that let's just say that you may have some extra assets or properties which you may have left out or you may have forgotten, and what is left after all the debts and administration expenses have been paid off, for example, like debts, your credit card bills, or even funeral expenses and whatsoever. So Section 8 of the Distribution Act stipulates that if there is no residuary clause and any other assets of the estate not mentioned in the will may fall as a partial intestacy. So in this sense, any foreign assets that you may have and may not be included in your will may fall under residuary clauses. Now, the next part of the talk would be how do you prove a will in different jurisdictions? For today's context, we won't be advising much on foreign law as we are not licensed or we are not allowed to do, but we will be touching in the context of Malaysian law. So as you can see just now, a will is valid in Malaysia if it conforms with the provisions under the Wills Act, Section 3, Section 4, and Section 5, which we have set out earlier just now. But what about foreign jurisdiction? Of course, most of it will really depend on which jurisdiction you are in, whether be it a civil law country, a common law country. All this would have to subject to the laws and regulations of the jurisdiction where you prepare your will. Malaysian wills, however, are generally accepted in common law jurisdictions, provided that validity of the will are in accordance with the Malaysian law and the terms of the will do not conflict any of these national law. However, in non-common law jurisdiction, a Malaysian will may not be recognized unless it complies with the local law over there. So for example, let's say you have properties or assets in Thailand or maybe Vietnam, because these are not common law jurisdictions, so it may be really hard for them to recognize your will. And at times you may have to seek local solicitors' advice and representation in transferring your assets or whatnot. Now, when it comes to estate administration, as we have briefly talked about just now, is either a grant of letters of administration and how do you draft up a will for your estate. So let's just say that if you only have a Malaysian will, what can you do next? If in the event the testator passed away, the executor of the will of the estate can apply for a grant of probate with a Malaysian will in the Malaysian High Courts. Once the application has been allowed and granted by the court, the executor can obtain the sealed grant of probate from the High Court, and subsequently, let's just say your Malaysian will has other jurisdictions assets, for example, Singapore, Hong Kong, UK, US, or whatsoever, and you want to distribute all these assets according to the deceased wishes, the executor has to file for a resealing application of the grant of probate in other countries. And this resealing application mostly can be done in some common law jurisdiction, for example, like in the UK or in Singapore. However, any other jurisdiction other than common law jurisdictions are, of course, subjected to the inheritance laws of the jurisdiction. So let's just say you've got a grant of probate in Malaysia, you want to enforce it and reseal it in the US, it will have to be subjected to the US local law, and it will be advisable for you to get a US local attorney's advice in doing so. The next thing would be these kind of wills and grant of probate are required to be translated into the language of the jurisdiction, where you have to appoint someone. Let's just say if the will or the grant of probate is in Malaysia, but somehow you have assets in Italy or even in France, and of course you want to be able to administer the testator's assets in France or Italy, then you have to translate into Italian language or French, and it has to be certified, legalized by the Ministry of Foreign Affairs and into the language of the respective jurisdiction. Only then the respective jurisdiction may take into consideration on whether to reseal it or to recognize the will and the grant of probate. Of course, like I have advised just now, it would be in your absolute convenience or advantage to appoint a local legal representative to reseal the grant of probate and also to recognize the will. Now, in the case of you having a multiple will, what next? What can your executor do and how the process will be like? So, of course, once you have several wills, for example, a will in Malaysia, a will in Singapore, a will in Australia, your executor can, of course, file for a grant of probate with the wills simultaneously into different courts, for example, in the Hong Kong court, in the Australia court, and also in the Malaysia court, all together at once. Once you get the grant of probate from the High Court, the executor is free to administer the estate in each jurisdiction immediately without having to wait for the grant of probate to be resealed. So this is a much more straightforward manner to conduct administration of estate. So as we have discussed earlier, there are several advantages and disadvantages of drafting wills, one of it being just a Malaysian will and the other one being different wills or multiple wills. So the advantages of having just a Malaysian will is, of course, the assets owned by the testator is more detailed, as in you don't have to worry whether there are any other wills. So all the assets would have already been encapsulated in just one will, and it will be clearer and more detailed for the executor to administer the estates. The next part would, of course, be saving costs and expenses. With just a Malaysian will, you can only just draft a will and then that's it. You don't have to draft different wills in different jurisdictions for different assets. Let's just say that if you only have a bank account in Singapore or only have a bank account in some other country, would it really be necessary for you to draft up a will just for that account? Sometimes we will advise that sometimes you can just terminate the bank account, close the bank account, and just transfer everything back to Malaysia. That would be the most convenient way. But let's say if you really want to keep the bank account running and operating, then of course drafting in one will there's nothing wrong with it. And when it comes to distribution of assets, there will be lesser inconsistency because the testator's intention and wishes have already encapsulated in just one will. So let's just say if you have only a will, and let's just say all your assets have already been accorded to give to 3 different beneficiaries, and everything else also give to all these 3 beneficiaries. So it would be easier for an executor to do it when it comes to just distributing to all these 3 beneficiaries according to just one will. And it's actually very convenient to draft just a Malaysian will because you don't have to. In some cases, it will be inconvenient for the testator to go all the way to other country just to draft up a will and then to witness before a solicitor, a lawyer, or anyone who prepared a will in that country. So for the advantages of multiple wills, of course, your assets are better protected. So you are able to list out each and every assets that you have in different country. And of course, this would be even better if, let's say, you have substantial assets in other countries. So for example, you own few properties in Singapore, few properties in UK, then and also a lot of other like immovable assets all over the world. Then of course, multiple will protects your estate the best. And when it comes to probate applications in the event the testator of the will passed away, like we have already mentioned just now, the probate applications can be done simultaneously, one shot, without having to wait for resealing application to happen or whatsoever. Once the testator passed away, the executor will be able to immediately work on the probate applications. And of course, the convenience of having different will would be each will is recognized in their own respective countries. So for example, if you have a will in Hong Kong, of course, it will be recognized in Hong Kong, and you make everything easier, which would result in easier enforcement of your will, of your estate administration in that particular jurisdiction. So for the disadvantage of having just a Malaysian will, if the testator only has a Malaysian will, the executor would have to file for grant of probate in the Malaysian court, and after that, if there are any other foreign assets in foreign jurisdiction, and it will be required to get a grant of probate in somewhere else to get all these foreign assets to be distributed, you have to bring the grant of probate in Malaysia to this foreign jurisdiction, for example, like UK or Singapore, to get it resealed. And the process of resealing a grant of probate from Malaysia, it may take a longer time. And also you have to consider that the will that you have drafted may not conform with the requirement, formalities, or even the law of the other jurisdiction. And some of the foreign assets, of course, will still subject to the laws of the foreign jurisdiction. For example, like I've mentioned just now, immovable properties or inheritance tax, or these kind of laws that Malaysia don't have. And there may also be additional costs on the translation of the documents. As the Malaysian grant of probate is in English, there may be chances that, let's say, if there are foreign assets in other countries, you may have to translate everything, including the will, the grant of probate, into the local language, for example, French or Italy or even Spanish. So these are some of the disadvantages that you may have to consider about when you just draft one Malaysian will. In the case of multiple will, these advantages may not have that much compared to a Malaysian will, but although there may be additional costs on wills drafting, which you may have to spend some time and effort, and also even legal fees on drafting different wills in different countries. And the enforcement and also interpretation of law may vary from jurisdiction to jurisdiction, and it is subjected to the local inheritance and also estate administration law. And there may be some inconsistency in relation to distribution of assets, because some of the will, let's just say in the context of Malaysian will just now, there may be only 3 beneficiaries, so everything will go to that 3 beneficiary. But if you have a multiple will, which, for example, in the UK will, it goes to 1 beneficiary, in the Malaysia will, it goes to 4 beneficiaries, and in Singapore, your estate goes 2 beneficiaries. The executor would, sometimes they may be confused as to, is it true intention and wishes of the testator, and how should they go about it. So there may be some inconsistency. And the last one would be, it would be inconvenient to draft different wills, because of course you, as the testator, you may have to fly here and there to different countries to draft up a will, just to draft a will, even though you may or may not have like substantial assets abroad. The last thought point would be on cross-border inheritance issues and solutions. So typically what a person may face when it comes to cross-border inheritance, namely that you have different assets in multiple locations all around the world. So some of the common issues to consider is that some of the jurisdiction, they will not recognize our will. For example, a jurisdiction that do not follow common law, such as like Thailand, France, etc. And some jurisdiction, they recognize the will, but they refuse to accept the terms of the will. So for example, even if you have drafted something in conformity with Malaysian's formalities of a will, when it goes to UK or goes to Singapore, if let's say any part of the will that isn't drafted in a manner which complies with the local regulations and law, chances are the jurisdiction, even though they recognize it, they will not accept some of the terms as it is in conflict with their local law. And also some of the issues that may face is which will to follow. For example, like I have executed a will in Malaysia, but then somehow I touch a bit on Singapore, and then I have another will in Singapore, and then I touch a bit on Malaysia, and which will to follow on how you want to execute, how you want to let your executor to execute the estate, and also which jurisdiction to follow. Let's just say you have a Malaysian, just a will, and different assets. What jurisdiction can you follow? So some of the suggested solutions, of course, it would be preferable if, let's say, you have substantial assets, properties all around the world. It would be preferable and much more better if you draft multiple wills in different jurisdictions, and to ensure that the wills that you have drafted or prepared do not conflict with or supersede each other. So let's just say that you have a separate will in Malaysia, separate will in Singapore. You just say that it's only limited to the local jurisdiction only. Malaysian will is only applicable to the local jurisdiction. Singapore is only limited to the application for Singapore law only. And make sure all the formalities of wills are met. So for instance, in Malaysia, as we have mentioned earlier, you have Section 3, the Wills Act to comply with, and also make sure that each will you have drafted in different jurisdiction, they conform with the local formalities of will as well. And last but not least, always consult a local practitioner in relation to inheritance law of the foreign jurisdiction. So if you have substantial assets, house, immovable properties, or anything, whatnot, it would always be preferable for you to consult a local practitioner on the inheritance law, so that it will avoid any conflict between cross-border issues. So that's all for my talk today. If you have any questions, please put it in our chat box, or even we have prepared a Q&A box for you all to have your questions for us to answer. I'll pass back the floor to Joseph. Joseph, over to you.
Thank you, Aaron, for your insights and it was an amazing and insightful session in relation to wills and in relation to drafting and proving wills for assets in multiple jurisdictions. We will now take questions from the participants in the Q&A chat box. Our first question we have from Catherine Lee, Aaron, is just to confirm, number one, we can write our own will, and number two, the will have to be drawn up, needs 2 witnesses. There is no need for the will to be stamped at the court.
Okay, thank you for your question, Catherine. Yes, of course, you can write your own will, but you have to have 2 different witnesses to witness that you have signed the will yourself. And when you are signing it, you understand that what you are signing, and you are of clear mind and as to how you want to distribute your assets or anything like that. And your will is not required to be stamped at a court, as it will be enforced when it comes to a grant of probate application. However, you have to take note that the 2 witnesses that witness the signing of your will cannot be any beneficiary of your will, of your estate.
All right, thanks. We have now questions from 2 anonymous attendees. The first question relates to the will writing process for Sabah and Sarawak. The question is it the same for East Malaysia as it is in West Malaysia, or is it just the applications for probate apply the respective state laws?
Thank you for this question. I think this is a tricky one, because as far as we are concerned, we are not allowed, nor we have any local standard to advise any estate administration process in relation to East Malaysia. However, as far as I am concerned, as your will would have to depend on where you located when you prepare the will. So for instance, if you have a will if you are from Sarawak and you have a will prepared in Selangor, so of course your jurisdiction would be in Selangor. However, if let's just say that you have passed away and you are applying for, and your executor is applying for grant of probate in the Selangor High Court, Shah Alam High Court, then of course you may have to bring the grant of probate back to East Malaysia for resealing purposes. And also the application for this grant of probate, of course, is still subject to East Malaysia's ordinance or even like their estate law.
Okay, thanks, Aaron. There's another one. Also an anonymous attendee. Sometimes the testator does not disclose his property around the world in specific, or they might have forgotten. So if the contents of the will do not comply with the foreign jurisdiction or the foreign laws, what will happen to the assets in that foreign jurisdiction?
Of course, if let's just say didn't disclose the property around the world. So for example, you have some money or some investments in the UK, then and it's not included in your will whatsoever, and if it does not comply with the UK jurisdiction, chances are it may still fall as a residuary asset in your will of the estate. So it has to be dealt with in accordance with the local jurisdiction. So for instance, if let's say the falls under residual assets, then you will have to follow the UK law as if there is no will being made for that particular property.
All right, thanks, Aaron. That's very helpful. The next question we have from the chat box. I would encourage everyone who has a question to put it in the Q&A box so it's easier for us to track. But there is a question from Siu Hua in the chat box. Aaron, what are your thoughts about having cryptocurrency or these kind of new assets that we're seeing in this day and age in wills?
It's not uncommon nowadays. I personally have come across clients that wanting to include crypto assets in their will. However, as far as I am concerned, the technicalities of cryptocurrency in terms of an estate would be on how can you identify and whether do you have any access to the cryptocurrency, cold wallet or hot wallet. That would really depends on whether the testator is willing to give the account details to you beforehand. As of now, because each cryptocurrency wallet is an anonymous address, which is like a long chain of alphabets and numbers, so it would be really difficult for you to be able to tell. Let's say you have a wallet with Binance or with Luno, and it would really difficult for them to release the money to you because each wallet, they only recognize the wallet by the wallet address, not the wallet's owner.
That's very interesting indeed. Another question from the chat. If we list our assets, how detailed do they need to be? Does this list need to be in the body of the will or can it be an appendix?
It can be both way. It can be either way. So let's say if, for example, it would really depends on how much assets you have. Let's just say that you have 4 beneficiaries in mind and you want to distribute everything to all 4 beneficiaries, then of course you can draft up your will can be structured in a way that says that I will give my entirety of the estate to these 4 beneficiaries in equal shares, and my property, my assets shall be listed in Schedule 1 or annexure to this will or something like that. So that will still be enforced.
All right. Okay, back to the Q&A box. We have a lot of questions today. Okay, in the event there is no will or the will is lost, I think this is a straightforward one. How can the children or surviving spouse get properties?
So it would have to depend. So in the case of if there is no will, then as I have mentioned earlier, it would have to go by way of the grant of letters of administration application, and the distribution would have to be by way of Distribution Act, Section 6 of Distribution Act 1959, which says that your surviving spouse get 1/3 of your estate and your children get 2/3 of your estate. If let's say the will is lost, it would have to determine whether the lawyer who drafted it owns a copy of it, owns a duplicate copy, or there's some sort of a duplicate copy around. If there's a duplicate copy around, then chances are you may have to rely on that to apply for a grant of probate and to come up with a reasonable explanation as to why this is a duplicate copy of a will and not the original. But if let's say no duplicate copy and the original will has already been lost, then chances are it may still have to go for a grant of letters of administration application, unless, for example, let's say you have filed for the grant of LA application, subsequently somehow out of nowhere, on maybe like suddenly you found your will somewhere, then you can of course file another grant of LA application with the will annexed in it.
Thanks, Aaron. I think that leads very well to this next question. Is it true that a will cannot be executed without the grant of probate?
Yes, that is correct. Because the will, as far as it's like it records the intention and wishes of the testator, you can't execute it without any official court order, which in this term we call it grant of probate. So if you want to administer the estate according to the testator's wishes, you have to bring the grant of probate to different authorities or even banks. So for instance, if there is a house to be transferred or to be distributed in the will, if you just bring the will, go to the land office, will reject it and say this is not the grant of probate, you can't just come here and ask to transfer the name or register the name on the land title based on the will. You still have to go and get a grant of probate. Similarly to some of the other like banks or even KWSP, EPF, they nowadays, I think sometimes they require to see that the EPF is listed on the list of assets and attached together with the grant of probate. So yes, the grant of probate is still required by law to administer the deceased estates.
I see. Thanks, Aaron. The next question in the Q&A box, I think it's an interesting one. It's a good question. So if I want to come and see you to drop a will, Aaron, what details must I have with me when seeking for your services to prepare a will or to draft a will, to ask you to draft a will? So property details as per the S&P, the IC of the beneficiaries, the passports, personal identification, anything else?
Okay, so for the beneficiary and executor details, it would have to be the name, the full name, their personal identification number, be it passport numbers or even IC numbers, and also their address. So these are the more important ones, as long as we can identify who these people is. So if let's say like the passport number is only valid for a few years and you subsequently, the executor or beneficiary, have a new passport, you can still use the previous passport number, but provided that it's the executor's passport, they keep their old passport and then the passport number, or the passport, in some countries, the previous passport number, they will be recorded in the new passport. So in relation to all the property details, it can be as detailed as the land title number of your property, your bank account number, which bank, the bank's address, or even in the terms of the shares, all the account number details. So these are the certainty of all these subject matters to be considered to put in. Alternatively, if let's say that you are just going to draft a very simple and cover all will, then you don't need to provide all these and you just say that all my estate to be distributed accordingly, provided that no immovable properties are included, is under your name. Because in the case of immovable property, it is advisable and it is quite necessary for you to put it under your will.
Thanks, Aaron. I think we, due to time constraints, we will just take two more questions, quick ones. One question from Juan Ling is, if foreign bank accounts are included in the Malaysian will, does the testator still need to consult a practitioner in the foreign jurisdiction or the Malaysian will?
For this one, it would have to depend on which country it is. So for instance, if it's in a common law jurisdiction, then of course you would still need to consult a lawyer in the foreign jurisdiction if you want to file a probate application. But for Malaysian law context, we will still include it in as general as possible, as to not go into specific details of it. So any inconsistency you may still have to seek a consultation from foreign practitioners. But as far as I'm concerned, in between Singapore and Malaysia, we don't really have this kind of difference in terms of the formalities and also requirements of a will. So I think if you have any bank accounts in Singapore, I think that shouldn't be any problem.
All right, thanks, Aaron. One last question for today. What happens if the executor dies before the testator and you're left without an executor?
If let's say your executor passed away before you and there's no alternative or substitute executor, then perhaps what they can do is the beneficiary can step up, or even the beneficiary of your estate can step up and be the executor and file for a grant of LA with will annexed, and also distribute all your assets in accordance with your wishes recorded in your will. So that is the more straightforward.
All right. Thank you so much, Aaron, for taking the time to answer so many questions today. I believe those questions will be insightful. For those who did not manage to get your questions answered, don't worry. We have a few announcements coming up that might interest you. So before we conclude, I just have a few announcements to make. The first announcement, please join us again for our upcoming talk on the 2nd of October 2024. It's a Wednesday. Understanding the proposed citizenship amendments and their implications. I'm sure some of you may be aware that there have been some proposed amendments to the citizenship laws in Malaysia, and our lawyers Kirtika Patmanaban and Aisha Rahim will be talking about these proposed citizenship amendments and their effects in Malaysia. Of course, you can sign up for more of our MWK online talks at this QR code. Please feel free to scan this QR code or look up this link. You can sign up for our talks here. Secondly, also, please fill up our feedback form and tell us what you think. The feedback form is in the chat box in the Zoom. Please feel free to fill up our feedback form and tell us what you thought of our talk. The link to the form is posted in the chat. Please do like our social media accounts, YouTube, X, Instagram, LinkedIn, Facebook, all that good stuff. You stay updated with more of our publications, any talks, any upcoming things that you may be interested in. And fourthly, if you would like to speak with our lawyers relating to today's topic or any other issues, legal issues that you may be facing, we offer a complimentary consultation up to 30 minutes over the telephone or over video conference. Please fill in the form on our website. The link is also posted in the chat box. And to our guests, thank you all for joining us this afternoon. We hope you have found today's session informative and useful. Thank you, everybody, and see you at our next talk.